Well, good morning, everybody, or good afternoon, or wherever you happen to be in the world. Welcome to this session. There's a full crowd here. I think probably most of it are here, so we're going to make a start, and people can join us a little bit later if need be. First of all, just as a reminder, you've hopefully all had an invite to join the VVOX system. We're trying this out on this webinar. It's what they call audience engagement, whatever that means. We're going to ask you some questions and give you a chance to tell us what you think, what the answers are, and see how that helps us to deal with the things that are coming up. So next thing I want to do is just look at the housekeeping matters. Oh, sorry, no, we got to introduce ourselves first. I think you probably know, you've seen the advert, the publicity stuff that came up when you joined this session, so you know a little bit about Richard and myself. I'm going to start off going through a few things, hand over to Richard, and then I'll take over at the tail end of it. So no more about us speakers. You can read all about us somewhere else if you want to know a bit more information. Okay, housekeeping, not so much to do these days because most of the stuff that we cover is already done. You know what to do in your own home and what to expect when things go wrong. If there's an alarm in my house, you might hear it, but you won't see me for dust. Anyway, look, we're quite keen on seeing questions coming up. We're very happy for you to ask the question verbally. If you do that, just put a signal on the note there, the chat function, to say you want to ask a question and briefly what it's about. Or if you just ask the question, just type it into the chat function, and we'll deal with those questions towards the end of the session. Anyway, if you wouldn't mind keeping your microphone on mute when you're not actually speaking, it helps to avoid the background noise. Okay, over to the agenda. This is what we're going to do. I'm going to take us, no, Richard, you're going to take us through some core principles of NEC and a little bit about the current international use of NEC, deal with a few cultural issues, things that are perhaps affecting how we might use the NEC in other countries. I'm going to look at drafting to deal with legislative requirements, and then we'll touch on dispute avoidance and resolution. At the end of this, we should have half an hour or thereabouts for questions. So we're quite keen on seeing what you've got to ask us, and we'll see what we can do. Okay, if you can start to do this question now, what country are you dialing in from? Just interested in whether you're all based here in the UK or whether you're from somewhere in the world. And just by the way, this software we're using isn't too intelligent. It's not very good on geography. If you write down you're in South Africa, it thinks you're in two different countries, one in South and one in Africa. So just one word, please, what you're calling from. So SA or UK or NI or whatever it may be. Anyway, just if you'd like to type your things in, see what we can get as a figure, how many people we've got from different parts of the world. What have we got so far? 8 people.
So we've got eight people. 8 out of 19 have dialed up to the VVOX thing.
Okay, we're closing that. So what have we got? Mostly UK, some in Holland, Wales, some gone sideways in South Africa. Is that?
I think so, yeah.
Okay, so there's a few people there. That's good. Second question, just a quick, simple. What's your level of experience from? Yeah, know a little bit about it, but never used it, through to a regular one. Just quickly type 1, 2, 3, or 4 and see what we get. See how many answers we get. That'll help us to organise things a little bit by knowing what kind of people, what level of people we're talking to. Okay, I think we've got most of the answers in now.
That's working quite well. I like it.
Right, there we are. Regular user, half of you nearly regulars. And a small percentage not really a lot of experience, some thinking about it and some have used it. So we got a bit of a mixture there, Richard. Some have used it a reasonable amount and some not so much.
As we know, Peter, that's always the way, whatever else we're doing in NEC.
Yeah, anyway, over to you, Richard.
Okay, so I love to start off presentations like this with my favourite line. What do you think? We're not asking you to give us an answer here. This is a very rhetorical question. What are the most dangerous words in the English language? I'll let you think for just a moment. Oh, we always do it like this. And that applies to most of the things we do in life, but it always also applies to contracts. If we're working with a client and we've always used the client standard terms and conditions, and the lawyers love the standard terms and conditions. We'll always do it that way. What we're asking people to consider, wherever you might be in the world or looking to use a contract in the world, there are different ways of doing things. NEC is one of those different ways. Move on, please. So the core principles of NEC haven't changed since way back in the mid-80s. Martin Barnes, who was the life chair of the Association of Project Managers, got together a few people to say, there must be a better way of doing procurement and contracts. There must be. First suggestion, flexibility. Can we have a set of contracts which is super flexible? And then we said, can we have them? We are clear. Radical concept. Can we have a contract which is clear? And I hesitate to use simplicity because it's clear. We can't claim the NEC is simple because it does take some training to get your head around it to do it properly. But the language is clear and simple. And lastly, please, can we have a contract which is a stimulus to good management? Wouldn't it be nice to have a contract that actually helped us do what we're trying to do, which in the concept of a construction contract is get something built. The concept of any project contract is get something done. Wouldn't it be nice if we can have a contract which helps us do those things? So very boring for those of you who know NEC inside out, but very briefly, carry on. We'll look at the headlines for each of these three things. In terms of, go back one, please, just go back one, I think. Go up one. So basic clarity, no clarity, next one down, sorry. Next one down, clarity. Firstly, it's in plain readable English, short sentences, bullet points. It's relatively straightforward to read. Contract NEC, all the big NEC contracts, that's not the short contracts, but they've all got a very good structure. They've all got a 1 to 9 core clauses, which we can get our head around and get used to. They don't dig into specific bits of law, but as we'll see from Peter later, if there are some very small aspects of local law that need a tweak, then NEC has a way of dealing with them within a particular so-called secondary option. Carry on, Sharad, please. Next one. Hopefully you've read that, you've understood it totally and clearly. That's just an example of the way many contracts write sentences. I haven't bothered counting the words, but there's far too many words in the sentences. There's loads of cross-references, there's cross-references, and it's just not easy to read. In comparison, move on, NEC's language is more straightforward. Give us a click. So firstly, the first sentence in NEC says the parties shall act as stated in this contract. Shall act. In my translation of that, I've always got it, do what it says in the contract. Basically, that's what you're told to do. But that one shall means that every sentence in the contract now is an obligation. You shall do it. So the rest of the contracts, as you can see there, is written in the present tense. This sentence I picked out because it emphasizes also the flexibility. The contractor designs the bits of the works which the scope states the contractor is design. So the contract is hugely flexible in terms of contractor design. Carry on. The contractor is required to submit particulars. It's all in the present tense. Do what it says in the contract. Next one, and in all the submissions, all the clauses in the contract where the contractor is required to submit something, there's then a clear statement giving the reasons for not accepting that submission. So just as an example of how the language is present tense and in simple, easy to read English. Carry on. In terms of flexibility, carry on, ping down, just do the whole slide for it. What is it? Firstly, any aspects of any project, any service. We've got contracts for supply. There are the ones for the relatively simple projects and they're more complex. And also, importantly, in any sector. The NEC, you might know, is actually owned by the Institution of Civil Engineers because they funded it, but it's not a civil engineering contract. It's a contract for doing stuff. How do we want to do contracts? any procurement strategy, almost, any level of contractor design we've just seen, a range of payment options you'll see later, and generally very, very clear and flexible risk allocation, hugely flexible. And where can we do that? What we're trying to show you today, we can do that pretty much anywhere in the world. Move on. That's the flexibility. And then picture here, left to right is what clients do with an asset. Y-axis coming up, big contracts, little contracts, more specifically complex contracts, less complex contracts. And if you want a consultant to do something for you, ping, you will use the NEC's professional services contract. If you want a contractor to build something, ECC contract, it covers any level of design and construction as we've seen. But contractors don't really do anything, they just manage subcontractors. Wouldn't it be nice if we had a subcontract form in exactly the same words? We do, engineering, contraction, subcontract. But those contracts are quite complex. If you want something simpler for the low level of project complexity, you can use the engineering construction short contract, which is the NEC's equivalent of a minor works contract. And guess what? We've also got that published in a form that can be used, dramatic pause, enter, as a subcontract. That's where NEC was way back in 2015. If you carry on clicking, you'll see we've now got a term service contract and a short-term service contract. That's providing a physical service. Carry on, we've got a framework contract, we've got an adjudicators contract, we've got supply contracts up at the top for just any, so you could buy an aircraft carrier with NEC with a supply contract, or you could buy a gallon of petrol with a supply contract. So contracts for supply, and then lastly, we've also got a contract for, keep clicking down, last one is a professional services short contract. Much underused, should be used a lot more. That's where we were in 2017. Along came, move on, the NEC4 new members, just click straight through them, Shredder, I'll catch up. We've got a slightly renamed dispute resolution services contract. We've published a subcontract for the professional services contract. Radically, there's now a contract for design, build and operate. And even more radically, because everything else so far has all been bi-party contracts, just with two parties, we've now got an alliance contract, which is for a joined up everybody in it together contract. And just to show that things keep moving, NEC is about to launch a facilities management contract, which is specifically, it's like the term services contract, but it's specifically using the language for facilities management. So those are just a couple of slides to show you the massive range of flexibility within the NEC contract. Move on, please. So for those of you that might come with a background of FIDIC contracts, which is the well-established contract used internationally, just a slide, takeaway slide really, to show that NEC's pretty much got it covered. Professional services contract is the equivalent to the White Book. And most importantly, FIDIC chooses to publish separately contracts for employer design bill of quantities, contractor design and typically lump sum priced, which is Yellow Book, and same again with even more risk on the contractor, Silver Book. All of those contracts can be mimicked and carried out using the NEC's engineering construction contract. NEC's got the two different types of subcontract, and we've now matching the FIDIC with its Gold Book. We now have the design and build contract. Where NEC has more things for us is the term service contract and framework and alliance contracts. Move on, please. Just to emphasize that, I always use these two dimensions for a contract, how much design is being done and what's the level of price certainty. Carry on. FIDIC Red Book is essentially for employer designed and is a bill of quantities. Click on, we've got FIDIC has Yellow Book and Silver Book, which are typically lump sum, but NEC, the FIDIC contract doesn't actually define the payment mechanism. That's for you to set out and do that as a bespoke contract. Silver Book, carrying on, is the next one in the picture with slightly more risk to the contractor. In terms of payment options, all of those can be covered by NEC because, click on again, we've got options A to E, lump sum, remeasurement. What FIDIC doesn't have yet is a target contract, which is becoming very popular. Better move on, lots to talk about, keep going. In terms of NEC, as we've said, NEC covers the entire patch because we can have the contractor doing any level of design. I'm not suggesting you'd probably want the contractor to do a lot of design with a remeasurement contract, but the option is there. NEC is being hugely flexible. Carry on. Stimulus to good management. Why does NEC do that? Excellent at communications generally. Keep going. We've got massive focus on a program. So NEC is very, very strong for program. NEC has a very, very simple process for putting your hands up and saying, we've got a problem, we need to talk. Let's talk about it in an early warning meeting. And probably most importantly, we've got a process for dealing with what the NEC calls compensation events. These are the only events for which the contractor can get any more time or money. One more for compensation events. Radically, they're all nearly in the same place in the contract, just one big long list. We assess the time and the cost for all of them. All of them are assessed in exactly the same way. And then keep going. Radically in NEC, we assess the effect of the compensation event on the real cost of the event, not necessarily on predetermined prices in the tender document. And I think the most important word in the whole of NEC, which has knock-on consequences for using the thing overseas, is the fact that we assess the forecast cost of the event. We don't just sit back and wait and see, which is the normal provisions in most other standard forms of contract. So compensation events are like that. We've got a clear process for assessment, and the big word, another click, is the forecast. I think that word forecast is possibly the most important single word in the whole of the NEC contract. Move on. Questions, please come in as and when you want them. The NEC is so systematic, we can manage it in the cloud, and there are several very, very good web-based tools available to help you do that. Excellent, excellent tools to support proper contract management. I look forward to the days when please find attached little form is consigned to history. It's not the way to work in the digital world that you and I now work in 2021. In terms of collaboration, NEC is very good inherently because it's got early warnings, it's got clear compensation event process. Keep on going. In clear compensation event process, as I've mentioned, lots of focus on program. You've got a secondary option to build in key performance incentives to incentivize whatever sort of collaborative behaviors you might want to pick out. As I've mentioned in passing, we have a concept of target contract, where suddenly the employer or the client in NEC4 is incentivized to collaborate because they suddenly have a genuine interest in what the contractor is actually spending, which is clearly not the case in a lump sum contract. Then NEC4 brings in for the first time in NEC and most of the standard forms of contract, it's the first time we've got an option to cover the procurement process, which has come to be known as early contractor involvement, where we bring in a contractor to work with us from the early stages to develop the deal, the contract effectively for the second stage. NEC's also got an option called X12, where we can build in cross-project incentives to encourage separately contracted people under separate contracts to collaborate and pull in the same direction. And then the ultimate in terms of collaboration is the NEC's alliance contract. So any user can decide how far they want to go down the route of collaboration with different options within the NEC family. Keep going. So a question back for you again then. Outside of the UK, whether you are UK born or otherwise, if you're working outside of the UK, what form of contracts do you tend to use? Do you use another standard form of contract? Do you use NEC? Or do you use some other completely different form of contract? Can you just type yourself into your webbox? You've got the skills, we got the responses before. We're just interested to see what other forms you're using out there. I've got 5 responses so far, keeping coming. At 6, just a sort of one-liner. What's your normal form of contract that you're using? Okay, that's good enough. Let's hit enter, see what our survey says. It's going to say FIDIC, surely. I wonder. Oh no, NEC4 project. FIDIC CCDC. I don't even know what CCDC stands for. I'm an ignorant person. Perhaps somebody can tell me. Just chip in if you're there. Take yourself off mute. CCCDC. What's that? Is that a UK form or is that one that I've not heard of?
It's a Canadian form.
Okay, thank you very much.
Yeah, no problem.
So that is a standard form.
Yeah.
Okay, and then brilliant. And in one word, why do you think you use that standard form that you've always been using? Is there a common reason why we use a standard form of contract? It's going to be interesting. It's quite difficult because we've got probably not enough online to get a general response. But is there one word to say why we use a contract? I guess some of you are going to say it's good. Be interesting. Maybe it's not interesting. We've got 6. We're struggling a little bit here. We've got 7. Why do you use that form of contract? Is it because you're told to, bullied to? I wonder. Okay, Siraj, that's good enough. They've had their time. What have we got? One word. Familiar. That's what I thought we'd say. It's easily, or it's World Bank, or it's standard. And I think the familiar word, I don't know whether that is genuinely a little bit bigger. It's probably a little bit bigger because 2 or 3 people have used that particular word, but it reinforces my point from before that people generally will use what they've always used before. Again, interesting that somebody has put in the World Bank, because the World Bank historically and currently still requires their borrowers to use FIDIC forms of contract where other forms are clearly available. Interesting. Thanks for that. Move on. So in terms of international use, where are we now with NEC? You can see the countries I'm going to talk about briefly. In the UK, it's pretty much the standard for infrastructure. It's also well used in buildings. In South Africa, where NEC first started out, one of the original drafting panel was from South Africa, and it's now one of 4 forms allowed by government. In Hong Kong, it's being very, very strongly used. It's now mandatory for government construction unless you've got a very good reason to tell your betters why it's not going to be used for this job. Carry on. It's also used and becoming more standard, not standard yet, but it's becoming more common in New Zealand. In India, it has been used for a few big airport projects. Carry on. The other ones are odd ones, really, outliers. Has been used in the Philippines. It was used for the massive International Criminal Court building in The Hague. It's planning to be used in Belgium, where they have actually translated the contract into Dutch, which I understand is a requirement of Belgian law that you have to have the contract in a local language. I guess that's a government contract. Exciting for me is that the contract is now being used in Peru. It was used for the Pan American Games and is now being used following up from that for some significant big river training projects. I'm very happy that one of my clients at the moment is a Spanish contractor wanting NEC advice to use NEC in Peru, bidding for those jobs in Peru. And particularly exciting, in Australia, the governments have been busily, the state governments have been busily driving towards wanting more collaboration in their construction industry. And it's good to see that they are starting to use NEC. So in terms of jurisdiction, firstly, as I've said, it was designed to be used internationally. And this must be now 10 years ago at least. His Honour Humphrey Lloyd, a well-renowned QC in the UK, wrote a very good article on NEC, which you can see on the NEC's website. And as a summary one-liner, no real barriers to using the NEC internationally. That was the line from Humphrey Lloyd. Moving on, what we've done with that, Peter and I have just recently published a short article. It's a 5-minute read, if that, talking about the issues we're covering in this webinar. So that's also available now on the NEC website. Just a basic update from where we are and some of the things to take into account if you are wanting to use NEC outside the UK. Carry on. So pitfalls for jurisdiction. What we would say is that you should not just jump in and use the NEC in a new country if you're going to use the NEC under a different law. It doesn't really matter which country you're using in it. What matters is the law which will apply to your contract. Carry on. So firstly, though, to get that review, we need a legal review by somebody who understands construction and understands construction law in the new country. But please train them first in NEC. They need to understand how NEC works before they start proposing changes to the NEC. NEC, one clause says the contract is governed by the law of the contract. That's fairly straightforward. As I've just been giving in my NEC training today, law of the contract, it's in italics. What does that mean? Answer, it's in a document called the contract data, where you need to write in it is covered by the law of Belgium, Holland, Australia, wherever. And carry on. One thing that the NEC does have is a one-liner which says this contract is the entire agreement between the parties. It's a very common, I'm not a lawyer, but this is a very common provision in contracts. Basically, it's saying, I don't care what you talked about before you signed the contract. I don't care what anybody else says about this contract. All that matters is the documents in this contract. Now, Humphrey Lloyd in his paper noted that in some countries that is just not legally true, and the law in some countries will allow other documents, for example, guide notes, to be taken into account, and even might, in some cases, the law might allow pre-contract documentation to be taken into account in the interpretation of the contract. So that's a particular issue that a local lawyer will need to look at. Carry on, please. Another issue is the project manager's role. Those of you who know NEC will know this very, very clearly. The construction contract, the ECC, has got a project manager. The professional services contract in NEC4 has now got a service manager. Now, those people are there, they're employed by the client, and they're very definitely managing, looking after the client on the client's behalf. As per that first clause, they are required to act as stated in the contract. And in the UK law, they are required, this is just case law in the UK, if you are put in a position of administering a contract, you are required to act impartially whenever you are using judgment. Now that's all fine, but inevitably when that project manager is sat in a room trying to agree the cost of a forecast for £100 million, for £100 or £100 million, it doesn't matter. The forecast for the cost caused by a compensation event, it was very difficult when that person, the project manager, is paid by the clients. It is very difficult to imagine that that person is going to be 100% genuinely impartial, particularly when we're looking at forecasts of compensation events. When it comes to assessing the amount due for payment, there are clear rules and it should normally be black and white. It's going to be more difficult for assessing compensation events. And that issue itself may present a problem in certain jurisdictions. Like I say, I'm not a lawyer, but it needs to be looked at in the particular contract. In terms of language, I've already told you that the Lantis has paid good money to prepare a contract good enough. That's not a very good terminology, but you know what I mean. Translating a contract is not straightforward. Even with the NEC's straightforward language, it is very definitely a specialist and professional skill. What NEC can give you is permission for the NEC words to be translated. And that has already been done in the cases you can see there for Spanish for those projects in Peru, and for Dutch for this one project which is cutting edge stuff in Belgium. So that's something that the NEC can give you, is the permission to go and get it translated. What NEC is considering, but point of fact hasn't done yet, is actually published an official translation of the contract. If NEC sees, particularly in South America, if we see the NEC taking off, there will be clearly more pressure on NEC, which is a business owned by a charity, to put some money into developing a document in Spanish. If the market is calling for that strongly enough, I'm sure one day it will happen. Carry on. Cultural issues, moving on. So culture, I think the big thing I've just told you, the big issue for NEC is firstly that you do have to manage it. Some contracts allow you to leave everything till later and get the claims guys and the lawyers in to sort it out. That is not the way NEC is designed. You need people to actively manage the contract. That's an issue. It's difficult in the UK. In training, I often jokingly ask the question, how long is it since you heard the words, "It's getting contractual"? Because some people see getting contractual as a nasty, aggressive, adversarial thing. No, it's just using the contract. So is that something you can make happen in the country that you're planning to use NEC in? Carry on, Shradza, please. And if you are going to make NEC work, you will need resources. You will need to train people. You will need systems, ways of managing, keeping track of the various communications required. All of those require resources and investment from the client side. But there are good reasons for that investment: better project management, and keeping track of where the contract is going. What we must not do is put the contract in the bottom drawer. We do need a collaborative mindset. We need people that want to work together. That is a different concept. Again, in some countries, contracts are still the rules for war, effectively. I gave a lot of training in Hong Kong, and Hong Kong government would not allow me to give NEC training without giving training in parallel on collaboration skills, in teaching people how to listen, how to work together. NEC does require delegation and empowerment. Who is going to make the decisions that the ECC project manager has to make in terms of accepting compensation events? Those decisions have to be made fairly quickly, and that sometimes clashes, as I've said here, with organizational procedures and requirements. Very often, NEC exaggerates and emphasizes the gaps in organizations themselves and the lack of procedures they have in place to manage contracts. You do need programming skills. Is that a control? It's not a cultural issue, really. It's just a resource issue, because NEC is heavy on program. We can't shy away from that. And ultimately, NEC will die. NEC will not work unless a client and the contractor together put in the effort to make sure people understand the contract that they're trying to use. Therefore, there will be training needed to make it happen. Deep breath. Peter, are you with me?
Hello there. Thank you, Richard. You can have a pause now, have a glass of water or whatever.
I will do. Thank you. Carry on.
I'm going to talk now a little bit about the drafting for legislative requirements. So it's really looking at what you need to do if you've got particular requirements in the country's laws which impel you to put certain things in contracts. Now that's a bit different from just simply saying we can put this in a contract because it's helpful to have it. There's an obligation to put it in. Start off, we're just going to look at the structure just to make sure we understand where this all fits. As you probably know, there's a set of core clauses. They will apply to all contracts regardless of what it's about. The core clauses are always there. On top of that, building up, we get a series of payment options. Richard talked about this flexibility and payment, A to F. They're all there. You choose one of those to fit with your contract. Any one of those, it depends on your particular procurement policy, what you're trying to achieve. We've got dispute resolution options 1, 2 and 3. I'll touch on those in a few minutes, so I'll come back on them a little bit later. So that's one of those. You choose one of your dispute resolution options. Now on top of that, you've got a lot of secondary options. Different contracts, ECC, term service contract, professional service contract, design, but they've got different options, slightly different options. Some of them apply in all of them, some of them just in some contracts, but they're there because you might or you might not want to have them. So most contracts have got something like retention funds in the contract. We don't have that in the contract. If you want a retention fund, you call up the secondary option. If you want delayed damages, you call up the secondary option. So these are choose according to what you want for your particular contract policy. Now on top of that, we've got we call Y options, jurisdiction specific options. Now these are the ones I'm talking about now. This is where the particular country has some special requirements which they say this is way a contract must operate. And I'll touch on a few of those. I'm going to explain one or two of them as to how we've been going about it in terms of getting those into the contract and making sure that they fit with the rest of the contract. Because the easiest thing possible to do is to write a load of clauses to deal with these country specific options and make a real mess of everything below there. The core clauses, the payment option, disputes, the secondary options get messed up if you write those badly. So that's why I'm really going to spend a little bit of time talking through what we've been doing and what we are doing so you can understand that. So if you can move on. Oh, nearly forgot. We have this special thing called Z clauses, the dreaded Z clause. You will always have something that you need for your contract which isn't actually covered by it. So Z clauses are written to deal with those extra requirements. Now, same sort of concept is going to apply to a Z clause as to a jurisdiction special Y clause. You need to make sure that they fit with the clauses. A number of times I've looked at some specialist written Z clauses which completely conflict with what's in the contract. Somebody writes it and says, well, I want to do it differently, so I'll write it in a Z clause differently, and forget to change the original clause, or don't understand the fact that it's overridden, it's conflicted with it, or it doesn't fit, says something different, and it makes a bit of a mess of the contract. So watch out for the Z clauses as well. Anyway, going into the Y clauses, this is the process. It's quite important to follow a process. You shouldn't just go ahead and write something because you think it's good. Let's just pick a step. Firstly, what's the requirement? First of all, you need to identify what is the essential need that must be included in the condition of contract, and distinguish it from things which can be in the scope or which can be optional. So you don't have to include something. If you do, you need to identify it specifically. This is the legislative requirement. Right, now work out how you're going to make it work. We've got thing which is something that Martin Barnes came up with this idea in the earlier, which I think is brilliant. We write a clause function statement. Don't write a clause, write down what you want the clause to do. What is your clause going to cover? What do you want it to achieve? Right, having done that function, you then look to see how you're going to do it. The ideal, the preference is always to add to the conditions of contract. We've got flexibility in the contract, so most times you can simply put in a provision which adds to what's already there. Sometimes, and I'll give you examples in a moment, we've had to do this, you've got to replace some clause in the contract, some core clause. It doesn't work because there's legislative requirement says it can't be done this way. Having done that, you then need to get the drafting done, and you need an experienced practitioner and an experienced lawyer to do this. You can't do one without the other. Sometimes your lawyer is a very experienced practitioner and can do most of the work themselves, but they'd always be working with somebody from NEC overseeing it, looking at it, and giving comments on it and doing some kind of review to make sure that from the practical point of view it's not going to cause a problem. We then need to make guidance notes and produce flowcharts. The flowchart's an important part of the whole process, making sure that things, if that happens, we know what goes on next. The flowchart takes you through it, and the guidance notes gives you a bit more advice as to how to create them. There is finally a process of publishing. Now, anybody can write a Y clause and pretend it's a Y clause, but unless it's published by the NEC, it will not be a Y clause. It'll be a Z clause. It's, in other words, it's a Y clause is by definition something that's been through this process and it's been looked at by NEC, and NEC says, yes, we're happy with it. It does what we want, it achieves the legislative requirements, and it works with the NEC contracts. So that's, if you like, almost like not quite a guarantee of quality, but it's a quality statement. Now, looking at where we are with clauses now. Those of you who've seen the contract, looked at it and worked with it, know that we've got in the UK 3 clauses covering the Housing Grants Act, Project Bank Account and Third Party Rights Act. These are particular requirements where the law says that whatever your contract says, this is how it must work. Now, the Housing Grants Act therefore covers things on payment and also on suspension. The Project Bank Account is a bit of an outlier. It's probably questionable as to whether it really is a Y clause, but it's specific to UK only because we've got the functions of a trust built into it. So it can't really be adapted or used in any other country without being modified. And then the Third Party Rights Act is just to explain what rights third parties have. Now, the only other published clause we've got so far are for New Zealand. We've written some clauses a few years back. It covers the 3rd edition and only the engineering and construction contract, whilst the UK ones are covering all contracts to which there is an effect. It deals with the Construction Contracts Act in New Zealand, and it is there at the moment, but we need to do something about that. So moving along to where we're going next. We've got a set of clauses written for Ireland. That's the Republic of Ireland concerning the Construction Contracts Act. This has been written jointly with an Irish lawyer. They a straightforward set of clauses which add to things which are in the existing court clauses, but explain how they work with the Construction Contract Act. Similar way to we've done with the YUK, the Housing Grants Construction and Regeneration Act. Same sort of approach we've followed there. Australia, we've got some clauses for Australia. They've gone through publication, they've been through the process, they're about to be launched, I think, and they deal with the security of payments legislation. Now, this was a fascinating task because in Australia, you think of it, well, we need a set of clauses for Australia. No, you need a set of clauses for each individual state. So we've got common requirements for security of payments, making sure that the contractor can get paid, regardless of what goes wrong. But of course, every state has to pass its own legislation, and every state's done it subtly different. So the Australian clause is quite a complex one in that we've got a sub-paragraph, a sub-clause for each of the states, or combining some states in some provisions. So we had to be a little bit of a jiggery-pokery to make them all work with different states. So that's looking a bit more complex. Now, the extra one we're going to be doing is to update the New Zealand clauses. Sometime later this year, we'll get round to updating it for NEC4 and also to take into account legislative changes. The law's changed since that clause was written, and we need to make sure that it fits with the current legislation. So those are things which have just been done and we're about to do in the near future. I just finally want to now touch on dispute avoidance resolution. Touch on it not because it's an important thing by itself, because it's important in terms of how the rest of the contract works. What we've got first of all, we've got 3 options. Initially, option W1, it was the dispute resolution option in NEC. And it was the way we think things should be done, which is that you sort out problems very quickly. It goes to the adjudicator gives the answer, and you get on with the job. You don't spend time afterwards arguing about things and trying to get it fixed. So there's no delay. You get your problem sorted straight away. The Housing Grants Construction Regeneration Act turned that on its head because it said you can't enforce people to make the decisions immediately. They've got to be able to raise their disputes at any time. So we introduced W2 to deal with that. So that's very specific to deal with the problem that the Housing Grants Act introduced. Now, in NEC4, we introduced this concept of senior representatives. What we try to do is to make sure that you don't go to the adjudicator under W1 or W2 unless it's really been looked at seriously by the parties. So each of the parties will identify somebody who is sufficiently senior that they have the power to deal with the issues and reach an agreement, reach some kind of compromise if needs be to avoid going to adjudicator. So the idea of that is that they will hopefully resolve most of the issues. And if they don't resolve the issue, then at least they will have identified what the issues are, and perhaps it's a narrower question that goes to the adjudicator. Both, of course, apply to them for adjudication, which is what we have always required, and then go to the tribunal, which can be the courts or it can be arbitration. Now, in the 4th edition, we introduced this new idea of a dispute avoidance board, a little bit like the dispute boards that have been run on, what's that contract called, FIDIC or something, isn't it? Been running for a few years. This is very much aimed, though, at avoiding disputes rather than determining them. If you want your dispute determined, you will appoint an adjudicator, and incidentally, adjudicator could be 3 people if you wanted it to be. So this is to avoid a dispute. So the idea is that you have 1 or 3 members. They will meet at the intervals in the contract data, so you've got flexibility as to how often you want them to meet and how often to come to site. There's no senior representatives. The dispute avoidance board is taking that role away from them. So if there's an issue coming up which the parties haven't been able to sort out by themselves, the contractor and the project manager in dispute over something, disagreeing over something, they can then come to the dispute avoidance board and say, look, what do you think? Dispute avoidance board will look at it and they will come back with a recommendation. They don't give a decision. They just say, well, I think that the way to resolve your problem is this, and this is a sensible answer. Go away and look at it. And the parties then have to go away and decide whether they're happy with what the dispute avoidance board has said. And if so, they've solved their problem. The parties themselves will resolve the dispute. If they don't, they then go to the tribunal, which is, again, it's the courts or the arbitration as decided at the start of the contract. Now, whatever your dispute process will need a formal review for compliance with local law. And this is one of the things we found in both Australia and in Ireland, that we've needed to make some special provision for disputes under the contract. So in Australia, for example, there's a procedure for disputes on payment disputes. So there's a concept in Australia, you can have 2 disputes. One is a payment dispute and there's some other kind of dispute. And the same thing in Ireland. So we need to be clear as to whether you're dealing with a payment dispute. And if so, that dispute is then handled in accordance with the state law or the national law in Ireland, and not in accordance with the contract. So you need to be very clear which particular dispute it is, and that in order to keep the reference to the tribunal alive, you need to be clear that that particular part of adjudication or dispute resolution is dealt with as though it were being done under the contract. Right, I think that's really all I need to talk to you about in terms of the use there. We just touch on something in terms of future. Where do we go in the future? What's the next thing? Now, in Hong Kong, there was a special 10th anniversary seminar there, presentation by a very senior man in Hong Kong. Can you see the slide next, please? Next. Well, here we are. Mr. Lam, who's the permanent secretary for Development Works Development Bureau at the Government of Hong Kong. He was defining the NEC as the norm of engineering contract. The norm, this is what we should be doing in the future. This is the right way of doing things. It's an idea of things to be going on. Anyhow, we now move to a session where, where next? Where next, Richard? Do you want to come with something there?
Which country? I've got a little NEC short contract in Myanmar, which has had a little bit of a delay at the moment due to a coup, which is interesting. But who knows where NEC is going to get used next? That's the question. You saw the map of the world that we portrayed before. It's no, anybody looking at it will say, well, after 25 years, we're still really only using it in places where people speak English. And it's sort of colonial, it's England, Hong Kong, New Zealand, South Africa, but it is stretching. And obviously, I'm slightly passionate and enthusiastic about NEC, and I'm keen to help it stretch in different countries. And for me, it's great to see that NEC is putting the effort in for these Y clauses to make clients in different countries make it easier for them to choose to use NEC. So that's where I am. Questions, anybody? I haven't been following any chat. I don't know whether there is any chat or whether there are any questions from anybody. Please give us some questions to make it more interesting for everybody. Or was it also totally clear there's no need for questions? I'm not sure.
We've got no questions at the moment, Richard.
which is a concern. Has anybody got any questions? Anybody got any thoughts? Any considerations? Any ideas how we help NEC in the direction of multicultural, multi-country usage? Or are you all very, very quiet? It's a concern.
No. We have one here from Higgins. I've got one or two coming through now. They suddenly started. NEC contracts were used in Scotland and Wales, not just England.
Did I keep saying England? I'm sorry. I'm sorry. Obviously, I should be saying in the UK. I apologise, Ian.
Okay, one from Philip van der Mullen. To what extent are case law decisions of UK courts implemented into the NEC4 contracts?
Good question. And as you know, Peter, they have had to be. There were some minor tweaks in October 2020. There were some minor tweaks which followed a court case about termination and delay damages. So the yeah, good question. So yes, they are implemented, and that there's an active mode for NEC needs to make sure that the NEC can be used. Certainly in UK, but I think when we made those changes, Peter, in the October addendum, they were likely to be just as sound for any other jurisdiction as they were for
just
UK.
come on this, because I was involved in doing the work involved in that. I mean, basically the one that Richard just mentioned as an example, we had a court case which made us look again at what we've actually got in the contract in terms of how the delayed damages were collected after completion, and we concluded that it wasn't a matter of changing the contract to suit the law. It was a matter of the legal case had made us realise that our contract wasn't as clear as it should be in terms of what should actually happen, and therefore we needed to change the contract. So we didn't change it in as much as to comply with the English law, the British law, as much as to make the contract clear, having identified a problem.
Right. Okay.
Where we have made changes, for example, we made changes fairly recently also in the Y clauses because of court cases indicated that there was a problem with that. So we will do that. But in general, I would say that we don't actually change contracts to deal with UK legislation. We wouldn't make a change to the core contract for that because it's not meant to be a UK contract. But we'll look at it and see how it works. Are there difficulties with countries adopting civil code, Richard?
Civil code, I'm not a lawyer, I'm not a specialist, I've never had to do it, I'll be honest, but the civil code in some countries requires people to use certain, almost the details of you will do it this way, you will use certain contracts. So there will be potential conflict, Peter, I'm thinking, and it will need to be looked at in a particular civil code in a particular contract.
Yeah, unless the code itself stipulates what contract must be used, then it's a matter of looking at the code, looking at the issues within the civil code and saying, well, are there any issues there that do not work with NEC? But yeah, for example, the Belgians found that there was no real problem with working with NEC. They needed one or two extra clauses to make it work, probably, but it does work. And I think it has been used in a number of civil code countries. So in concept itself, it doesn't cause a problem. It's a matter of what the code says. And that's where, as Richard said, you need legal advice. Okay,
interesting one here is the magic spirit of mutual trust and cooperation. As many of you will know, is the first line, or line 2 now in NEC4. Interested to know how that's in Spanish. I don't know the detail with how that was. Peter, have you got any inclination on how that was done in Spanish?
No idea at all.
NEC.
I'm sure it was there'll be something there, but my guess is that they will actually use a different phrase which fits with trying to work together in a proper way, kind of thing.
Yeah, as I always give in my any NEC training course I always give, I translate those first two sentences. Shall acting state of the contract do what it says in the contract. A spirit of mutual trust and cooperation. There's PhDs written on that, but ultimately it comes down to talk and listen to each other before you engage with each other and start firing notices to each other. So the principle is very, very straightforward. But I can imagine some lawyers making it more complicated than it ought to be, really. I think. Go on.
I was going to say, this comes back to the point you were making, Richard, about translations. Translation is, on the face of it, fairly straightforward because it's simple English. But the trouble is in concepts, and this is a perfect example of one where you've got this concept of a mutual trust and cooperation. We think we know what it means broadly in the UK. What we need to find is a set of words in Spanish, French, German, whatever, which carries the same concept.
Yeah.
Simply translating it literally will not work.
I agree totally. Yeah. Serious question. The UK puts millions of aid into West and East Africa. It's all World Bank funded, and then we have to use FDIC. It's not a question of being prevalent. That is the rules. If you borrow my money, you have to use FDIC. The banks have been saying that for the last 20 years.
Just interrupting a second, Richard, because we had long sessions with World Bank a few years ago, and we actually persuaded them to publish a note that says you can use any internationally recognised contract. I think the bit at the end was as long as it's FDIC, but the basic concept is that they can do it. But then what they say is that they will need to be persuaded by the client, the person who's getting the money, that they have the capability of managing the contract that they've chosen, and they will have to choose the contract. So they make it very difficult to use others than NEC.
Which is fair enough. So you're right in correcting me. It's not an absolute blanket ban on using anything else. To the contrary, you can. But that's only right that you should be required. The challenge NEC has is that the world has been conditioned to use FDIC because of that support from the banks for the last 20 years. That's something we're still fighting against. Is there any? Sorry?
Can I just go to Rob's a moment?
Yeah, go on.
Rob's put this point about Latham report, Hong Kong's report. What other countries cry out with such a need? I think that a lot of countries, as their construction matures, they do realise there's a need. At the moment, there's a big review in Australia, for example, looking at what they should be doing, because they're all saying, look, the contracts are going wrong. We've got too many disputes. We've got too many arguments. It's costing us too much money. We're wasting effort. Yeah. And there's a review going on now that we are, to some degree, NEC is providing an input to give some ideas about how NEC's gone about it, to contribute to their review as to where they want their construction to go. So I think countries are doing this. It's a growing thing.
Okay, getting short on time, but I'm keen to go on forever. Do NEC have resources or connections to resources who can assist with cultural training of different clients in organisations in other countries? That's a really good question, and one that I think we'll take away. I'll take that one back for Cheryl and the rest of the NEC team, because I think it would be good if NEC could play some pointers to that so-called cultural training. Not aware of it at the moment. Is there any plan to develop specific services contract for the PM role for NEC? That's an interesting one.
Well, can I jump in here, because this is fascinating. I first started getting involved in NEC back in the very, very early days. We'd written the engineering and construction contract. It was the only one that was available. And I was asked by Martin Barnes if I would write a professional services contract for the project manager for the NEC. Okay. That was my brief. I got a small team together, and we looked and said, why should we limit ourselves just to the project manager's role? So the professional services contract came out of that. Okay. In order to deal with the project manager's role and any other role for any other professional organisation involved in construction. Right. So the supervisor, the quantity surveyor, the architect, the lawyer, the everybody. Yep. So it's not a matter of a specific service contract for the project manager role. That it does exist already. It was written back in the late 90s, I think. Yeah.
What's needed? What might be useful, Peter, is that I think if you were just employing a project manager for a construction project, a project manager under ECC, I would suggest that the professional services short contract might well be the best contract. And there, the question is, would it be useful to have some suggestions on that for making it easy for a client to employ a PM? So I think maybe there is a piece of work in terms of what the scope document would look like. And ultimately, it would just say, do what it says in the ECC contract, essentially. but they might need a little bit more than that. But I can imagine using the PSSC for that. Maybe there's a piece of work for an article or maybe a product from NEC to make that easier.
Yep. Bit more guidance.
Yeah. We've got new messages. There's plenty of questions coming in now, which is really great to see. Can we get access to a copy of the slides? Slides and the recording of the webinar will be made available on the NEC website very, very shortly. Not a problem. That's the normal procedure for these things. And please share it with your friends. I think it's important. This is Rob here. Hello, Rob. I think it's important to seek out what users believe they need in their countries and what efforts can be made here to canvass need opinion. Well, that's a good question. Like I say, the first stage is making people aware that there is this thing called NEC out there, which is part of the reason for this presentation. Next question is, what is it of interest to you ultimately as a country? And the people that we need to get to are the people ultimately, generally at government level, that write local government contracts. I know there has been some attempts to get to some of those African countries, for example, and help them with their procurement regime. It's not only the contract, it's also the whole procurement issues. Let's have a look, see if there's any of these questions we've missed. Any more questions? Keep them coming.
How can NEC compete where banks seem to favour FIDIC? I think it's the same as the last question, really. But
it's the same, yeah.
The key thing, to my mind, is that we need to be talking to the clients or putative clients about what they want from a contract. Because if a client comes to goes to the World Bank and says, look, I want to use NEC, and this is why I want to use the NEC, and this is how I'm going to use it, I think the World Bank would have great difficulty in turning it down. If they simply say, oh, I've heard there's a new contract out there called NEC, I think I'd quite like to try that. They'll probably get a negative response because they won't have the skills or the ability to do it.
They clearly going to need support.
So we do need to talk to the organisations involved in projects worldwide to tell them about NEC, make sure they understand it, and give them the assistance they will need to be able to run it properly.
Indeed.
Finally awarded.
And that's a big part of the cultural issues we talked about. NEC is not easy. It does need resource. It does need training because it's different. But it mainly needs the resource because of my forecast word, because NEC requires us to put the effort into forecasting the effective compensation events, mainly client changes, as we go along. And as a client, if you want your project to be properly managed, then I would recommend you have a very good look at NEC rather than just doing what you've always done.
Looks like we've run out of questions, Richard.
Well, that's good because we're only 4 minutes over, Peter. So hopefully that was of interest to some people. If it was interest, there's probably a feedbacky thing coming up. Be interested to see how you thought we got in trying to get the message across. Please share the paper. Please share the webinar with anybody else that might be interested. And clearly, NEC is there to help with anybody, any new client looking at NEC as a possibility. And indeed, any new country looking at NEC as a possibility.
Good. Okay, well, thanks for your time, guys. It's an interesting session. There's some good questions there. We enjoyed it. So from Richard and myself, goodbye and happy NECing.
Okay, thank you very much. Cheers now. Bye now.